Form 12-901B 3 is Florida's standard dissolution petition for couples with no marital assets, no marital debts, and no minor or dependent children together, filed by one spouse and served on the other. This video walks through what the form covers, who should use it, how service and the response window work, and which other forms typically go with it. Form 12-901B 3 Petition for Dissolution of Marriage with No Dependent or Minor Child or Children or Property is a Florida Family Law Rules of Procedure form. It works as a standard, one-sided petition. The filing spouse, called the petitioner, files it and then formally serves the other spouse, called the respondent, rather than filing it jointly. This form may be used when the couple has no marital assets and no marital liabilities. Neither spouse has minor or dependent children together. Neither spouse is seeking alimony, neither spouse is currently pregnant, and either spouse has lived in Florida for at least 6 months before filing. If a couple agrees on everything and has no children, Florida's joint petition for simplified dissolution of marriage, Form 12-901A, may move faster since both spouses sign it together and both attend a single hearing. But that process requires giving up the right to request documents from the other spouse, to a trial, and to appeal. Form 12-901B 3 is the better fit when either spouse wants alimony, wants the ability to request documents or ask questions about the other spouse's finances before a trial or settlement, or wants to preserve the right to have matters reconsidered or to appeal. After filing, the case can't move forward until the other spouse is properly notified. If the filing spouse knows where the other spouse lives, personal service is used, through a process server or the sheriff. If the other spouse's location genuinely isn't known, Florida allows constructive service in limited circumstances, using a notice of action and an affidavit of diligent search and inquiry, though that limits what the court can order, generally excluding alimony. If personal service is used, the respondent generally has 20 days to file an answer. From there, the case proceeds one of 3 ways. If the respondent doesn't answer within 20 days, the petitioner may file a motion for default and then request a final hearing once the other required paperwork is filed. If the respondent answers and agrees with everything, the case is uncontested, and a final hearing can be requested once mandatory disclosure is complete. If the respondent answers and disagrees with something and the issue can't be settled, a notice for trial is filed after disclosure, and some circuits require mediation first. Along with Form 12-901B 3, a case generally also includes proof of Florida residency, a notice of Social Security number, a family law financial affidavit, due within 45 days of serving the other spouse if not filed with the petition, a certificate of compliance with mandatory disclosure, also generally due within 45 days of service, and a cover sheet for family court cases, filed with the first pleading. The statewide circuit court filing fee for a Florida dissolution of marriage is $295, under Florida Statute Section 28.241. For anyone who can't afford it, Florida law allows filing an application for determination of civil indigent status for the clerk to review, and filing fees can be deferred if the applicant qualifies. Anyone whose case involves domestic violence, sexual battery, aggravated stalking, harassment, or aggravated battery, and who wants to keep their address confidential, can file a request for confidential filing of address instead of entering that information on the petition itself. If keeping track of all of this by hand feels like a lot, that's exactly what Virdix is built for. The wizard at Virdix.co walks through these same questions in plain language and prepares Form 12-901B 3 along with the other paperwork a case needs. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure the paperwork is complete and consistent from the start.